Hi there, welcome back to Monaco Solicitors. Our consultation today is with my client Stella, who is, got her back to you because she wants to maintain that kind of anonymity. Welcome, Stella.
Hello.
Hi, thanks for coming in. Would you like to give us a little summary of the scenario, or like what is it that you need advice on?
So I need advice on what I can do with my current employer, because I have had a self-employed teaching contract for 4 or 5 years, and then it's been suddenly changed to employed contract. And the terms of the self-employed contract were not really self-employed. It was not really legal, I think. And other teachers have not signed this contract because it really didn't sound good. But then the change was even worse in a way, because now we have this rolled up holiday pay that I think is also not, from what it says on the Gov website, that shouldn't be there. So I can definitely see something is wrong. Plus, I wonder if the fact that it's affected my pay, if that's also illegal, because now I get paid less from the way that I'm taxed. And then in the event of leaving, I want to know just what the conditions are and what the notice period will be even, and if I can keep some of the students that I've been teaching privately, and so on. Lots of things.
Okay. All right. And I think the issue about teaching some of your students privately, I think that's quite important to you, right? So,
well, actually, it's because I've been teaching for 5 years, and I know they really want me to teach them. And it's true. I mean, you do invest time and effort in teaching people, and you create a bond with them. So the client should be the one that chooses. But of course, there's also the contract that says something. So I need to look at what's possible and what's not. I just want to consider if some of them really want to study with me, because I know some of them travel far to just study with me at the school, and they would be really disappointed if I left.
yeah.
So I just want to see what's possible.
Okay. So just in summary, you started this teaching job about 5 years ago on a self-employed basis. There's some things in the contract that really weren't genuinely self-employed, really. And then most recently, in September, you signed a new contract, which is a contract of employment.
Yeah.
So you switched to become an employee according to that.
We had really short notice. We had 1 week. Some people just flatly left because, I mean, they had just 1 day of teaching. I couldn't. It was my full-time work. So we had 1 week. We couldn't even look over the contract. We had to sign right away in order to get paid. So it was a change, really, really sudden. We didn't even have time to say anything.
Yeah.
It kind of threatened, no, you're not going to get paid if you sign this any later than 2 days from now.
Wow, that's interesting. So the company hasn't been behaving particularly nicely towards you guys.
Anybody, yeah.
So to recap, in September you signed a contract of employment. That's what it looked like on paper anyway. So you went from self-employed to PAYE.
Yeah.
And in the contract of employment there are clauses which we call restrictive covenants, or post-termination restrictions, which stop you from taking your students with you when you leave. And of course, now you want to leave because of the way the company's been behaving. Even historically, you weren't that happy, you feel ready to leave. But crucially, can you take your students with you, especially if they want to come with you? They should be allowed to. So let's look at that. Now, I've got the first contract that you signed. There's one clause here that says that the teacher may not provide tuition effectively to any of the students that they've met through the company, apart from working through the company. And then this actually applies if the teacher leaves the company afterwards. So that's the clause that would have stopped you from taking them originally. Now, the thing about that clause is that it hasn't got any kind of time limit on it. It almost seems that it's forever, that you could never teach any of these students. So that clause is almost certainly too wide to be legally enforceable. Clauses like this have to be quite narrow, have to be defined, in a period of months, perhaps 3, maybe 6, maximum really in your job. I mean, you're not like a senior executive kind of role here with like top secret confidential information. You're just a teacher, right? So, because this purports to be forever, a judge would look at that and say, that's not enforceable. So you don't have to really worry about that old contract. What you might need to be more aware of is the new contract that you signed in September. So, a few months ago, so we're talking about, 6 months ago, less perhaps.
Yeah.
Now, in that one, that looks like you are an employee according to that one. So they've been paying you PAYE, okay, and you've been taxed at source. You say you've been getting less money, I think, overall.
Yeah. Which I also think it's weird, right? Doing the same job, getting less money. Is that normal for them to change contract like that?
It's not very appealing. I think a lot of people would do what you're doing, which is to get some advice and think about leaving.
Yeah.
It's not illegal, as it were, to pay people less money. But of course, it can be constructive dismissal if they've been employed for 2 years. So you could argue here that you have been employed for 5 years, and actually that what they're doing is constructive dismissal, because you could argue that the previous self-employed contract, because it was so strict on you, you could hardly take a day off. They weren't agreeing days off. It was specific set times and places. They controlled everything, and it was for many years.
Yeah.
That looks like an employment situation, but then they were just trying to avoid paying the tax.
Benefits, yeah.
So you could argue that you were employed then, and then what happened in September was constructive dismissal. So you could leave and sue them for financial loss in between jobs. The fact that we're now 4 months later, nearly 5, is a problem potentially, because they could say that you've left it too late. So if an employer behaves badly and you resign, that's fine. But normally what you've got to do is you've got to work under protest if you're going to stay there. You've got to flag it up, preferably in writing. Say you're working under protest, perhaps submit a formal written grievance, then go through the grievance appeal procedure. And then when you've exhausted all the internal procedures, then you need to resign pretty quickly. Or if you don't go through the grievance route, you just need to resign quite quickly in response to the so-called breach of trust and confidence. So the longer you stay there, the easier it could be for the company to say, yeah, potentially we did something that was in breach of trust and confidence, but you accepted that breach by staying. So there's a slight...
I'm needing to pay rent.
This is the dilemma.
Yeah.
This is the thing. So, you could say, why wait till now anyway? Is there a specific reason to wait?
Actually, to have full-time teaching that you can live off of is not that easy. So, I have been looking for other schools to work for, but in the same time, I've been kind of juggling other things. So I've been actually taking more private students in my days off. So I started working 2 more days a week, which gave me less time to apply for other jobs. It's like
Fair enough. Okay. Well, let's look at the clause in here anyway that talks about what you can and can't do with students. So in here, it says, you will not, so effectively for 6 months after the last day of employment, and within 5 miles of any of their sites, do any business with any person who in the last 6 months from your last day, going back in time from that time, that was a client of the company, and that you taught. Interestingly, by the look of this, you could, if you taught them more than 5 miles away from the closest office, then it would seem that they're okay with that, because they only restrict anything happening within a 5-mile radius. Would that work for you? Could you teach students outside of 5 miles?
Well, some of them, I would go to their house.
Yeah.
So some of them do live that far.
Perfect.
But some of them don't. Some of them may live really close.
Okay, so the ones that do live that far, you could go to their house. As long as they're living 5 miles away or more from the office. It's quite unusual of them to have this in there. You see, most clauses that you see don't have a geographical restriction on there. So it could be a client anywhere. Most of these types of clauses would say any client. Yeah, it could be anywhere around the world almost, right? I know teaching is not a global profession, but for some reason they've decided to put within 5 miles. Let me just double check that.
And is it just for 6 months? So then if I wait 6 months, they can still have me as a teacher?
Yeah.
They really want me.
Oh, yeah. Yeah, 6 months after your last day, you can do whatever you want, in terms of taking it.
So then that's easy, because the ones that are really desperate for me, they can call me after 6 months for sure.
Absolutely.
I can tell them, after this day, you can contact me.
Absolutely.
Right. Well, interesting.
So I've looked into a couple of options for you, because I know we discussed before the possibility that you could just leave, deal with the students anyway, and then kind of hope they don't notice, and with any luck, no one will notice and it's fine. That is definitely a possibility, on the basis that the contract itself, your argument would be that the contract itself is unlawful. So they've effectively torn up the contract by their bad behaviour and put it in the bin. So there is no contract. They're the ones who ripped it up. And by leaving, you're accepting that they've done that. So there's nothing in here stopping you. The problem with that is that suddenly if you leave and suddenly the students that you were teaching all leave, it might look a bit more than a coincidence. And there seems to have gone to a fair bit of effort with this clause, with this contract. So they could try to make your life difficult. It's worth saying that they could take you to court and take out an injunction in the High Court. It's unlikely for a teacher, especially. If you're, like I say, a CEO of a big company, then yeah, that's what happens all the time in corporate world. But to be honest, in the teaching world, it's very unusual. But it's possible, and you should be aware. And if that did happen, a judge would look at that and say, well, you signed the documentation and you didn't say anything to them before you left. You weren't open about it. So they might hold that against you and say, well, you should have known, and what you were trying to get away with something here. So there's another option where you can say to them, look, I'm leaving and I'm going to take these clients. You tell them the names of the students, and you're going to let me take them. And if you don't let me take them, then I'm going to sue you for 5 years of holiday pay, which you should have paid me when I was working for you self-employed. But of course, you weren't self-employed. You say I wasn't self-employed because you had all the control over me. I couldn't take a day off. It was very difficult. I had to work specific hours, days, all the kind of control tests that make it much more like an employed contract. So at that point, you could do a deal with them in writing, where it's, in the open, as it were. It'll still be confidential between you and them, not public.
Yeah, I just think it's because they're just impossible to deal with.
Yeah.
Even to the point of ridiculous, where nobody's got anything to win. They just like saying no, just for the sake of saying no. Like, just don't make them happy. Don't say yes. To the teacher. Whatever the teacher asks, just say no. It's almost like they run under this policy. So
yeah.
It's very bizarre to imagine even that they will agree to a deal like that.
Yeah.
Also knowing of their behavior, and after, I know they lost a case or two before, and how they behaved after that as well. And
Yeah.
So I'm just not looking forward to. Yeah, maybe I should be more bold and present the situation. I think maybe that's the right thing to do, right? But I don't. Yeah, I don't know how I would go about doing that.
Yeah, the thought of the conflict is a bit too much for you
Yeah.
at this point. I think it's hard when you don't have a lawyer, especially if they've got a lawyer.
Yeah.
Then you could be receiving letters that you don't know what to do with. It's easy if you've got your own lawyer. You can put they understand the pressure, the stress. They've done it before. It's their day job.
Yeah.
If you're on your own, I get that. Most people don't want that fight. It's interesting that you could have a claim for 5 years of holiday pay.
And do you think, I mean, yeah, I don't know if it's worth the conflict and the money as well, because if you go to court, then there's that expense. And of course, I could have maybe with the union, I could have some free legal support. Yeah, but then I don't know. I don't know what's the best way to just get out of this.
Sure. I mean, okay. What I was saying there as well, I think I hear your common sense points, that you're concerned, and of course you should be. It's common sense. The thought of going to court or getting a lawyer, it's expensive. It sounds like a lot of difficulty. But what I was trying to say was, if you could have a claim for 5 years holiday pay, so let's say it's around a month of holiday per year on the average employee. I don't know if you're 5 days a week or only 3 or something, so it would be
4,
so it'd be pro rata, so it might be 20 days a year. So for 5 times 20 days is 100 days, so a third of a year's income, which would be, I'm sure, many thousands of pounds. I mean, you could have that claim anyway. Doesn't matter what you decide to do, whether you want to leave quietly or not, or do it all openly, or take the students with you or not. You could still have that claim. I'm not, I don't know. So let's say you're getting 30,000 a year, so that claim would be 10,000 a year, right? Or if you're getting paid 20,000 a year, that's a £7,000 claim there, right there. So a union would look at that, and potentially you could get a lawyer to look at that on a no-win, no-fee basis, ideally for you.
Yeah.
It's difficult to get that, to find lawyers that do that. Not many firms are specialist enough to know how to do that. They just see a lot of risks for themselves.
Yeah.
We do that, and we'd have to look carefully at all the, even this is just a quick look, right? A quick consultation. We'd have to look deeply into the paperwork, and it's before taking on something on that basis, we'd have to be really sure we could get that kind of result. Yeah. And the fact is, you by the sounds of it, you probably don't even want to go down that route anyway.
It's just, I know it's a bit stressful, isn't it? I mean, it's true, it wasn't illegal. I'm not even the only one in this situation. I'm thinking about all my colleagues that have been under the same, all calling sick if they wanted to have a day off. And yeah, it's not just me. I'm thinking everybody should do that all together.
How many of you are there?
I don't know. 20?
20. Yeah. So you get 20 and everyone's got a claim for £10,000. You have lawyers queuing up to look at your case, Suddenly, wow, they think that's a valuable case. Because they would then take a percentage of that, which would be quite a lot for them. So, suddenly, but obviously organising 20 people to make a claim is, I'm not saying it's a full-time job, but it's not what you had in mind, I think, before you came.
A lot of people who are unhappy just left, or didn't sign, or
Well, that's what happens normally. Because employers they're holding all the cards. They've got your paycheck at the end of the month. They could not pay you that. They can make your life difficult, not give you work. They've probably got lawyers because they've got more money. So a lot of employees are bullied into things that, are wrong, frankly, and by and large, employers get away with it.
Yeah, and they have even, I've heard that they would not book students for the people that they wanted to just get rid of. So they would also dismiss people in these very unlawful ways.
Yeah.
Just
instead of saying, look, let's sit down. I need to talk to you about this. You're doing these things wrong, and being open and honest and like a responsible employer should behave. Just make their life difficult, manage them out, hope they leave.
Yeah, all sorts.
Yeah, very common. Okay, well, you've got a few options there to be thinking about. So I don't know if you have any specific questions at this point.
I don't have a question on the notice because, well, I guess it's similar. So I have in the self-employed contract, I think it says over there is like a term, 1 month or something like that,
right?
Or I don't know how many weeks, and then the new contract says that, well, in my case, because I've been there for about 5 years, I would need to give about 5 weeks. But I wonder if these contracts accumulate, or because I signed a new one as employed, I can consider that I just need to give less than like 1 week notice now that I've signed a new contract because it's employed. Is it like the same kind of company? Does it include my previous contract or not?
Well, looking at this is your new contract.
Yeah.
That's the termination clause there.
Yeah.
So it seems to say after your probation period is finished, 1 month.
Yeah.
Is that right?
But was I under probationary period? Because I've been working for them under this other contract. So that's what I'm not understanding.
But you signed this new contract, right? Yeah. So legally, it is a bit of a grey area when contracts are, in themselves, the contracts are unlawful. But the fact is that on the face of it, without going too deeply into the scenario, you did sign this new contract. So it probably does apply. So therefore, and you have been working under it for a number of months now. Mm-hmm. So if it, on the basis that it does apply, according to this, on completion of your probationary period, it's 1 month's service, 1 month's notice. And then does it say that you've completed your probationary period? Doesn't say anything about probationary period.
No, because at the same time, I've been there for 5 years. So I wonder if they expect me to give a 5-week notice, one for each year that I've been working, like it says,
Yep. Well, you haven't been told that you've passed your probationary period, right?
Well, no, because I wasn't on it, I think.
Well, you could just give 1 week then, under this.
Okay.
And, the fact is, when employees give short notice to employers, it's actually very difficult for employers to do anything about it anyway, because they'd have to show that they lost financially by not having you there and that they couldn't get a replacement. But actually, they're not paying you for the time that you weren't there. So they've not lost financially by paying you more than you worked. So they'd have to show they physically couldn't arrange cover for your students. And I imagine they probably could arrange cover. So they'd struggle to show that you're gonna cause them loss. So I'm gonna go with 1 week here.
You see, it's just good to know, because what they're doing is we're also not supposed to, tell the students that we're leaving. And even if I wasn't planning to tell the students at all, after teaching them for 5 years, I don't want to tell them that I'm leaving, because they'll be really upset.
Of course. Where does it say that in it?
That's actually, that's what they're saying. I don't know where they say that we cannot, give our, contact and all of that. And so, we're not even supposed to say that we're leaving. So
I mean, it's interesting now with social media and LinkedIn and Facebook and Instagram. People can find people.
Yeah.
Whether they give the contact or not.
Yeah, but it would just be plain rude to not say.
Yeah, absolutely.
And so so if I had less notice to give them, then maybe I would just need to think what to do, really.
All right. Well, have a think about it. Let me know what you want to do. And best of luck if I don't speak to you.
Thank you.
Cheers. Well, thanks very much for tuning in to another Monaco Solicitors Consultation. Stay tuned and subscribe to this channel to be updated for our next one. Give us a like for this video. And if you've got any questions about maybe this case relates to a similar case to your case, just put them in the comments below this video on the YouTube channel, or get in touch with us via our website, link also in the description below. Thanks very much.